moderator of this panel really needs no introduction. He's considered one of the preeminent immigration attorneys in the country, and certainly in the Central Time Zone. Paul Zuhlke is a best lawyer. We all know that he was one of our great ALA presidents. We also know that he's continued his service to the immigration bar as chair of the American Immigration Council and has led it to new heights. It's obvious that the country knows who Paul Zuhlke is because he's been mentioned in many news stories in the Wall Street Journal, Washington Post, Business Week, and the Chicago Tribune. So I give you your moderator, Paul Zuhlke.
Thank you very much, Chuck. A pleasure to be here, and keeping with tradition, I'd like to introduce my co-panelists. First, the one you haven't met, to my immediate left, Eric Board. Eric is with the DC office of Morgan Lewis, national law firm, and his practice focuses on immigration matters, business immigration matters, and as well as I-9, E-Verify. He heads up the firm's immigration compliance practice, which of course makes him an ideal candidate to be with us today. And you met Tina earlier, and just to keep things fresh, I'd like to thank the conference organizers, Chuck and Marcine. They've provided me with a stolen identity that I can use to reintroduce Tina to you so we can look at her in a totally new light. Now, actually, one thing Chuck forgot earlier during his introduction to mention that Tina was recognized as a result of her work on the IFCO prosecution with a top prosecutor award by Women in Federal Law Enforcement in 2009. She truly is a nationally prominent prosecutor, and we are absolutely thrilled to have her with us here today. Really adds a lot of gravitas to our panel. Like to get right into it, but start with what we're planning to do so you have an idea. We're going to follow actually the title of the panel, which is ICE and U.S. Attorney Negotiations, and to warm us up, Eric is going to lead a discussion on recent developments and trends in ICE civil penalty negotiations. Following that, and we're going to have a little fun with that since we don't have an ICE representative on the panel, but we're going to talk about what we've seen in different parts of the country. Then we're going to move into an overview of NPAs and DPAs, and then finally focus on NPAs and DPAs in the immigration context, how they're negotiated, how they're structured, and finally how they are implemented. And this is a new and, as I think you'll find, a somewhat scary tool that has been rather common in other areas of law enforcement, Foreign Corrupt Practices Act, Medicaid fraud, Medicare fraud, and there's been a few moving into the immigration area, and with the increased emphasis on immigration enforcement coming out of the Obama administration, I think we're likely to see more. So let's start. Eric, what have you been seeing in terms of the ramped up enforcement activity in terms of what can be done with ICE?
What can be done with ICE? I can think of a few things, but none of them are particularly politic. Let me just start by saying that I don't purport to have any kind of monopoly whatsoever on insight or good ideas here. There are some very talented practitioners here in the office, and I hope what we can have today is a real exchange. There's a microphone there that I hope will get used a lot so that we can share stories, share experiences. Most of what we can report back about experiences with ICE is anecdotal as practitioners. There isn't a lot that we can turn to in terms of tangible material. So to the extent that we can share experiences and share insight, I think it'll make this a really much more productive session for all of us. So with that preface, you know, I think certainly one of the differences that we've seen within the past year or two is versus prior administrations is an explicit acknowledgement by ICE that I-9 investigations are lead-driven. There was a time, I think, when local ICE offices might have sent special agents around and they would have kind of picked a business or said, that one looks like there are a lot of a certain kind of people working there. Let's go check out their I-9s. And there was kind of carte blanche to do that. Well, the word now is that if you get a notice of inspection, there's a reason behind that notice of inspection. It could be for any of the myriad reasons that Tina acknowledged earlier. You know, somebody drops a dime, there's something in the media, there's something that comes up from an investigative context that's unrelated to immigration that leads to an immigration-related inspection.
And
But
if I could jump in there, Eric, also, Eric and I did a panel with Brett Dreyer, the head of ICE Worksite Enforcement in Chicago in November, and he also mentioned the increased utilization of referrals from other law enforcement agencies, both federal and state and local. And one development we've seen in Chicago, for example, where an individual goes in for, say, a family-based adjustment of status interview, kind of clean type marriage case, but the individual's undocumented. And during the course of the interview, the USCIS adjudicator says, well, where do you work? And engages them in a little conversation and, you know, talks about it, and they're making notes, and, you know, they're passing that on to ICE and, you know, that sort of thing, along with, like, local law enforcement.
So we've seen that type of focus where the inspections are lead-driven. But still, I think the really aggressive prosecution is reserved for the egregious violators, where what transpires or what's alleged centers principally on paperwork-type violations. That's almost always going to remain within ICE, and it's something that is going to be resolved ultimately through some sort of conversation with ICE special counsel, and in much less frequent circumstances, perhaps taking it up to the Office of the Chief Administrative Hearing Officer, Judge Thomas at Okaho or Okaho, depending on, I think, your regional preference. And those will be settled for money. Money, money, money. And I've kind of seen mixed results around the country. There are some offices where I feel like I've been dealing with Inspector Javert, and there's been no reason to rake this particular employer over the coal, but like a pit bull, this team, whether it's the special agent in charge or trial counsel, I really don't know because it's a kind of good cop, bad cop thing going, but it was relentless, and we ended up having to settle for something that I thought was really ultimately unfair, but it was preferable to litigating. And I'd really like to hear what Tina has to say about this at some point, but I've not seen any prosecutions based strictly on constructive knowledge. My sense is that where there is actual knowledge, and there's plenty of low-hanging fruit for prosecutors if that's what they want to pursue, that's what they go after. But if it's a question of making a case, a prosecutor is going to opt for the actual knowledge case where the facts support that than to try to prove a constructive knowledge case.
Well, if I could jump in here a second, Eric, contrary,
Anytime.
with all due respect to our friends in the government and at ICE, it's kind of like the argument on what's happening with secure communities. You know, we're really targeting criminal aliens, and those are the people we're trying to remove. Well, you know, the numbers indicate something slightly different, which may be why New York and Illinois and other states have opted out. You know, in the area of worksite enforcement, and I'm talking strictly civil here, at least my experience in I-9 audits in the last 18 months, which have occurred around the country, I've had some national clients, you know, the focus has been largely on paperwork violations. And no suggestion, even when the paperwork is really, really sloppy, and as you know, it so often is, that there's actual knowledge or constructive knowledge. You know, those are, you know, I think more challenging cases for the agency to make, whereas really, really bad paperwork can be a very easy case for them to make. And, you know, as Tina mentioned at the end of the earlier panel, at the end of the day, it's all about money. And it's a fairly easy way for the government to hit employers hard and generate significant civil penalties.
I think that's all right.
I do feel compelled to speak on that.
We figured we'd bait you sufficiently so that...
I can't speak to immigration and their ICE and their administrative practices with respect to fines. But certainly in a criminal context, it is never our intention to go after money. And in fact, you hear it all the time. You can't buy your way out of a criminal indictment. That's not to say there aren't a number of options that resolve in restitution or in fines or in forfeiture, but in case there was any suggestion that that's what motivates the prosecution in a criminal case, I just want to make clear that
Well,
that is not.
thank you for clarifying. It certainly would not suggest that. And in fact, most of the cases that I've experienced, there's absolutely no suggestion by the ICE investigators of any sort of criminal activity. But they are drawn to the money. And Eric, let's talk about the money. In the last couple of years, we've seen the release of the civil fine memo, and we had a nice discussion earlier about the Holy Grail, the Paul Virtue memorandum from way back when. Are you seeing consistency in terms of, the civil fine determination, civil penalty determinations, and substantive versus technical, and how that all plays out in the negotiation?
Yeah, I'm seeing a great deal of consistency in the total inconsistency across the country. I mentioned Inspector Javert, who handled, coincidentally, two separate matters for two separate clients. And one I was advising, one I was directly involved in the negotiation, the other I was behind the scenes and advising the client whose in-house counsel was handling the negotiation. For some reason, that one, the one that was handled by in-house counsel on fairly, well, I guess less egregious facts, resolved with a warning letter. And the first one, in which I was involved, where we had tougher facts, that was the Inspector Javert situation. So I think even within offices, there will be reasons why certain clients or certain companies are treated differently, and some of that may be invisible to us. But regionally, geographically, I've seen great inconsistency in a variety of areas. Now, earlier panels today talked about the various types of violations that could be detected in an audit situation, and specifically how issues of timeliness are going to be treated, or how issues of missing I-9s are going to be treated when you do a remedial I-9. In my experience, when speaking with trial counsel in various parts of the country, they will frequently have very different approaches to what constitutes a violation, what is something that can be negotiated away, what's something that is black and white, and what's something that's gray.
Well, what I really enjoyed about this morning's panel was the logical, very neat, wrapped-up approach to how the law states what should be done and how that contrasts to what is really happening in the field. For example, the statute of limitations discussion that Chuck led this morning was really excellent and great, and I've had conversations with local ICE agents as well as ICE Regional Counsel. Statute of limitations? What statute of limitations? We never heard about this. Can you tell us about it? And you give them the information. You cited the current case, and they say, oh, okay, well, that then goes into the mix. So, and of course the wide disparity among the local ICE offices on what constitutes substantive and what constitutes technical. It's unfortunate that since 1998, when Paul's memo was published, they haven't had the chance to issue regulations, but it's only been 13 years. So, maybe one of these days they will, and there'll be some additional clarity. I say when Eric and I appeared on this panel in November with Brett Dreyer from ICE, he promised that they were working on, and he stated this publicly, not privately, they were working on more detailed policy guidance that would lead to a regulation that would clarify, what's substantive and what's technical. And, it's only been 6 months, not 13 years, so we haven't had that yet, but hopefully, that will come out soon.
And that the matrix memo, the worksite enforcement memo that's in the book, that's in the appendix of the book, that was going to be revised because it had some issues, and the agency wanted to take another crack at that. That too was promised, but it hasn't yet materialized.
Well, in the matrix memo, there was a discussion of mitigating and aggravating factors. And in your experience, how have those been applied? And they were discussed, I think Marcin this morning talked about them, itemized them. What have you seen in the field?
I've seen, not surprisingly, a variety of approaches. And it's all going to be rather fact-specific, and there will be facts that support or don't support certain aggravating or mitigating factors. It's all open for negotiation. Remember, when you're in a settlement discussion here, this is a settlement negotiation. You've already been issued the notice of intent to fine, and ICE has already come up with what it believes to be the aggravating and the mitigating factors, and they found the box on the matrix, and they've decided that it's going to be $935 per I-9. But then when you're talking to ICE counsel, everything's on the table for a negotiation, and that includes the mitigating and the aggravating factors. So Judge Thomas in New China Buffet, she said they're piling on. When they've got you at $935 per I-9, they've already decided that you have a substantial number of violations. So why add another 5% for having a lot of violations? That's already factored in. I have had that issue come up, and I've argued back to ICE counsel, no, you should scrap that 5% because that doesn't belong there. And look at New China Buffet, and they say New China Buffet is what is it? And I give them the Okaho site, and they read it. Some of these ICE counsel, by the way, are going to be much more familiar with the enforcement jurisprudence than others. These are typically ICE trial attorneys, the same attorneys who are going to be appearing in immigration court arguing removal and similar issues are the same trial attorneys who are going to be litigating sanctions issues. Some of them may get a real kick out of it, and it might be what they really like to do, and for others, it's a real nuisance. And it is a distraction and a time sink from the enormous docket that they have to deal with in managing their day-to-day immigration court docket. So keep that in the back of your mind while you're negotiating with ICE counsel also.
If I could just pipe in, the same is true for assistant United States attorneys across the country. I am one of maybe 15 people in the Department of Justice who knows these statutes inside and out. And so immigration is really a specialization criminal lawyers are not often familiar with, and you can do your client a great benefit by educating the prosecutor who's on the other end of the phone, or the U.S. attorney asking for a meeting, explaining the administrative aspects of immigration law that we're completely unfamiliar with.
Well, on that issue, in terms of the knowledge base of the ICE counsel, of course, there's going to be regional variations. In Chicago, which is a really big office, the head of the ICE regional counsel and I were joking. They were saying they haven't had one of these cases since the Clinton administration in Chicago. They just haven't had them. And there was only one attorney, an older attorney, someone almost my age, that actually did this in the Clinton administration. It had anything to do with employer sanctions, just because there hasn't been that much activity in Illinois, during the Bush years. But back to the, I don't want to leave the mitigating and aggravating factors, and I'll pick up on a theme, Tina, that you mentioned in the earlier panel, and that in terms of evaluating good faith efforts on the part of an employer to comply, anything that happens after a notice of inspection doesn't count a whole lot. Would you agree?
On an administrative end?
Yeah.
I do think one of the considerations in whether or not you charge a corporate entity is the remedial steps that they take when the wrongdoing is uncovered. So it doesn't matter as much as what they tried to do before they got in trouble, because of course they're going to, do whatever they can not to get charged. But it does matter. It is a factor in the criminal evaluation. I wouldn't imagine it would matter administratively.
Well, I have found that with mixed results. I think it can change the dynamic of the negotiation with ICE counsel if I can go in and say, in in an initial conversation, you know what, this was a real wake-up call for my employer. And we really do want to get this right, and we take compliance seriously. And this is what we have done almost instantly when this came to our attention. Does that change where you are on the matrix? Maybe not. Does it affect what would happen if you got to Okaho? Maybe not. But does it help to perhaps reframe the dynamic with trial counsel so that your conversations are perhaps more productive and you might be able to extract some concession in the negotiation process? I think so. And I also think your client's going to get there anyhow. You know, the client's going to have to do these things. Whether it has to have been a wake-up call for the client. So if you're going to do it, my advice to the client is do it now. Do it before I have that first conversation with ICE counsel so that I can go in there with something rather than getting to the end of a settlement negotiation where now we've got to sign up for E-Verify or, God forbid, image. And
well, I mean, in terms of the negotiations, it's just been my experience that you're much better off if your client, from the moment that the notice of inspection was first served, if they are extremely cooperative. Any sort of belligerence or pushback is just going to make, you know, cutting a favorable deal all that much more difficult. And, you know, Eric mentioned E-Verify and image. It has been my uniform experience that if an employer is willing to swallow hard and say, okay, we are going to register in E-Verify going forward, that actually is very helpful in the negotiations. You know, ICE, you know, from an agency perspective, they're really pushing it, and they really want everybody to be in it, and someday we all will be. And it does help the negotiations. Now, you know, that does cause some employers to let some things go. Among them, this is going to make perhaps recruiting new employees, you know, a little more challenging with all those tentative non-confirmations that they're likely to get given, you know, a workforce profile. But that's the price, perhaps, of, you know, a reasonable settlement with the agency.
The question, is there any downside to not acting immediately? Is there any liability associated with acting immediately? Why would you not? When would you ever advise an employer not to act?
for the purpose of the recording, the question is, is there ever any benefit to not acting immediately? Can you think of a situation in which we might advise a client not to take some sort of immediate remedial action for fear that it might somehow or another work to the client's detriment? I could hypothesize about, perhaps situations in which that might be the case, but I think they would really be the exceptions.
I think the only time it really hurts a corporation is when the cold hard truth is you're going to have to terminate some key employees. And you've discovered, gee, I've got to let my head of HR go, and the controller, and the CEO, and that's a hard practical thing to deal with, and so there is some delay leading up to that decision. But otherwise, I can't imagine that there's a downside to it.
Now, one sticking point in civil penalty negotiations, Eric, that seems to be really hard to get past is a non-admission clause in the agreement with ICE. What have you seen?
Well, I'll start by saying that I've not had any success, even though I've tried, and I've tried on numerous occasions. But I think that's as much a function of the facts that I've had to deal with and my counterparts. But let me kind of step back just a second procedurally to make a point. When you're served with the notice of intent to fine, the regulations say that you have, I believe it's 45 days in which to signal your request for an administrative hearing before Okaho. And if you don't, then you waive that. I, as a matter of course, always request the Okaho hearing. I don't think that ICE counsel views that as me being belligerent. I think ICE counsel views it as me being diligent. And I also think that it is a very important right that needs to be preserved for the attorney, because otherwise ICE counsel has all the leverage. You're in their forum and you're not getting out. And it also means that you're now negotiating in the shadow of OCAHO jurisprudence much more explicitly than ICE policy guidance, because the venue to which you would go in the event that there was a hearing is Judge Thomas, and she's going to be applying OCAHO jurisprudence, which, as we've heard in earlier panels, in some circumstances diverges from what is in the ICE policy memoranda, and specifically with respect to how the matrix is applied. And Judge Thomas also takes the position that she's not bound by the dollar figure in the notice of intent to fine, but that she can diverge from the sanction and come up with her own number. So as a matter of course, I request the hearing. The other point there that I think is critical, and this is one that I don't know how this is going to resolve, is that if you look in the regs, and if you look at the final order, the Form I-764, the final order that ICE issues when they are, when a fine is being imposed. The Form I-764, up until recently, did not contain an admission of wrongdoing. It wasn't in there. You could settle a case with ICE without admitting wrongdoing. And in the most recent iteration of that form, which is being used by some offices but not all, but presumably it should be used by all offices, and it's a little bit difficult to get your hands on, but it's out there. The boxes that you check all include an admission of wrongdoing. So if you're going to use the Form I-764 as a final order, there's a requirement that the respondent, that the employer, admit wrongdoing. Well, I had a conversation, I can't name the person because he promised me, I promised him I wouldn't, in the office of the ICE legal advisor. This was about 1.5 years ago, and I said, this doesn't make any sense. You know, you're settling a case. If you're settling a case, why should you be compelled to admit to wrongdoing? The settlement ought to have some facility for you to avoid that sanction, particularly after hearing what Dan was talking about today in the areas of corporate liability. You can imagine the companies really want to avoid any sort of admission of wrongdoing. Granted, it's civil liability in this context as opposed to criminal liability, but it could still, in some circumstances, generate the cascade of securities-related litigation, class holder or shareholder litigation. If the stock drops, then you have a risk of stock drop litigation. It can become a nightmare. And the person in the legal advisor's office said to me, the 764 is not mandatory when you're settling a case. The 764 is required if there is a final order issued because you've been non-responsive to the notice of intent to fine, or a final order has been issued because I think of it it's in the reg and it's escaping me right now. It's 8 CFR 274A.9 D1 and F. But basically, the notion is that if you are resolving a case outside of OCAHO, so if you have not requested a hearing, then you're going to be stuck with this final order. But if you request a final hearing and then you reach some sort of settlement, you ought not to be required to use the I-764 form as the final order resolving that litigation.
Well, that's been my experience where I've requested the hearing, but that still gets us back to, you know, where they're at in terms of a non-admission clause. And I'd like to second what Eric said about Dan's presentation. For any public company, this is a really big deal. And, you know, the usual response that I've received from ICE counsel is, well, we can't. That's the policy, we just can't do that.
That's right.
And I've had a little bit of luck with certain adjectives, you know, that you can kind of slip in there, you know, inadvertently, you know, but you don't get a whole lot, okay? You certainly don't get what a company might get, say, in the SEC context, you know, when they're, you know, settling some sort of securities law violation. So it's going to be a hard swallow for some companies in terms of having that in there, and at least in the current climate, an extraordinarily difficult thing to negotiate. Eric, let's talk a little bit about structured settlements, particularly in context of the ICE publicly stated policy that they're not in the business of putting companies into bankruptcy, you know, as part of a civil money penalty settlement. Yet, particularly with, you know, smaller, medium-sized businesses, some of the penalties that they are seeking, you know, could nudge a company a little bit closer to Chapter 11 if there wasn't some relief. What have you seen the agency willing to do in terms of, you know, alleviating that issue?
You know, in my personal experience, I haven't seen a whole lot of flexibility, but I haven't been in the situation where I needed to force the issue. So I'd be interested in hearing what you and what others may have experienced.
I have. It was, you know, work something out or Chapter 11, and they said, okay, we'll work something out. And it wasn't easy. It was installment payments over a period of time, not all that long, but enough that the company could manage its cash flow, its credit lines in order to keep going. And, you know, there were appropriate provisions in there for default, you know, an acceleration clause, for example, if the installments weren't made. And it was approved by Washington, you know, under the circumstances of that particular case. I don't think that would be something one could get, you know, all the time. And this kind of segues into, you know, probably one of the most painful issues for an employer faced with significant civil money penalties is, you know, the last shoe to drop is typically the notice of suspect documents. Here's the list of your employees that we believe, you know, have documents that may not be valid. And, you know, they're always very nice, the investigators from ICE say, you know, send them on down. We'll be happy to talk to them. Or send them over to SSA and, you know, let's see what they come back with. And if they come back with something, let us know what they come back with. We'll recheck it and we'll fix it. But at the end of the day, in many of these situations, you know, depending on the workforce profile, you could have a significant percentage of the total number of employees not being able to fix it. And then as well, when do you terminate them? And I have found that, you know, the ICE, particularly the investigators, are actually fairly, at least in the Midwest, they're pretty reasonable in terms of, you know, phased termination. You know, you agree to, okay, let's say we have 100 employees we have to get rid of out of, say, 125 or 150, like the entire production team and the plant. And if you got rid of them all at once, you're looking at bankruptcy. So we don't want to do that. So, you know, you can, under the right circumstances, negotiate a phased termination, like a rolling notice, rolling termination, while the company, on the other hand, is aggressively recruiting, hiring, and training to replace these people. And, you know, you have to focus on, well, who are they? What is their role? You know, it's one thing to, you know, eliminate immediately entry-level production people. It's something else when you're talking about employees been there 10 years and they're supervisory and they're running equipment that takes 6 months to learn how to work the equipment so you don't cut your arm off, you know, that sort of thing. And, you know, you have to put that all into the mix, and it is essential to get it in writing in some fashion, I think, with the ICE investigators. And that can be email exchange. Here's the list. Here's what we're going to do, and we'll report. It's very important to report and give them progress statements so as a continuing demonstration of your good faith, or the employer's good faith, in complying with the agreement.
And I've had exactly the same experience, where there is flexibility in that respect. There's certainly nothing regulatory or statutory or even official and policy guidance that says that employers need to terminate individuals who are identified in a notice of suspect documents within a certain frame of time. There are different milestones that one could point to, or markers rather. You know, you could look to E-Verify in one context, and is it 10 days or 90 days? You could look to Social Security no matches, the old reg, and say, is that 90 days? You can look to the 2008 ICE guidance that kind of says implicitly, we know this can take some time, and employers and employees can challenge this, and the agency can take up to 30 days to decide whether to interview somebody about whether the person is working lawfully. So there's a whole lot of by analogy, there's a whole lot of suggestion that there is no fixed period by which somebody needs to be terminated, and which by inference suggests that there is this opportunity to negotiate something that makes sense. I don't think that that was necessarily the case 3, 4, 5 years ago, but I'm sensing that that ICE is more amenable to that in the current environment.
So those are for the good guys, just the civil penalty clients. And now we need to get Tina back engaged here and talk about the not so good guys. And Tina, for pretty much all of us who don't know a whole lot about criminal procedure, can you tell us a little bit, just an overview about the policy guidance you received from the Department of Justice and some of the general legal considerations that go into a decision to go forward with one of these cases in terms of a criminal prosecution?
Certainly. There is almost on a daily basis some sort of policy guidance that you get from the Department of Justice sent to us through email. It seems almost daily. But there's a lot of guidance out of Washington on how to handle cases in general. And there's something called the U.S. Attorney's Manual, which is a public document. I've had a number of defense attorneys take portions of that and cite it back to me, but that is sort of a manual that governs all U.S. attorneys in their decision making. It doesn't confer any legal rights to individuals, but it is guidance for how we're supposed to prosecute them. I think in these Worksite cases, I'm not really aware of any particular Department of Justice guidelines, but rather on these cases, the lead is from the agency. And there's certainly, in the past 2 or 3 years, a lot of guidance that's come down from their headquarters to the field in terms of different priorities and different techniques that they favor, whether they're going to proceed. Seems like the trend is now with I-9 audits. And so essentially, it's how the cases are presented to us from the agents. You had asked at the very beginning about the change in whether you have constructive knowledge cases, or I guess as you saw in our criminal statutes, we really call those reckless disregard cases or actual knowledge cases. And I think it's really an issue for us of how widespread the conduct is and how egregious it is. And so you may not have evidence of actual knowledge, but if there is a lot of harboring conduct or a lot of transportation, housing, bringing in undocumented aliens, we would proceed on a case like that whether or not there's actual knowledge, if we could establish reckless disregard. I have seen a change in how the agency is handling the worksite enforcement violations, and that they are now using an I-9 auditing process. And I don't know if you folks are busier. I would guess you are in the past 2 years, because when I started doing worksite enforcement cases, they weren't using the I-9 process at all. And it seems that there is some political directive coming down that we're going to start using this administrative process in preference to the criminal cases. But the guidance, I think it's just our general guidance on how to handle a criminal case, how to handle wrongdoers. There is particular guidance about how you charge a corporation that I can address later, but those are the general considerations.
Well, you started answering a question on the earlier panel and then thoughtfully caught yourself, so we could talk about it and have a little fun with it. How does a case or an investigation that starts as civil typically transition to a serious criminal investigation and prosecution?
That has to do with our principles. I was just talking about this U.S. Attorney's Manual. And part of that U.S. Attorney's Manual governs there are corporate charging factors that we take into consideration. And very often in these employment cases, there will be facts and circumstances. I said earlier, employment alone is not enough for a criminal case, but usually you have something more, and you could develop a criminal case. When you have a corporation, you're looking at the employees, the managers, directors, anyone who could have acted on behalf of the corporation, and then the corporation as an entity. And you actually indict the corporation and whatever employees are involved in the conduct. Obviously, you can't send a corporation to jail, and in addition to the normal considerations such as the likelihood of succeeding at trial, the federal interest, the adequacy of a non-criminal approach, so you have some administrative remedies. You evaluate those things in every case, but with respect to a corporation, there are 9 specific factors that we look at. The first is the nature and seriousness of the offense. And this factor ties in the priorities of the agency. So, for example, if ICE considered worksite enforcement a low priority, when we were evaluating an immigration case that had to do with worksite enforcement, we would take that into consideration. As I indicated earlier, it's a high priority for the agency, and this is where it's going to come in when you look at the nature and seriousness of the offense. The second item, and I think one of the most important, is the pervasiveness of wrongdoing within the corporation, including the complicity in or the condoning of the wrongdoing by corporate management. Was it people at the bottom of the rung, or did it go all the way up to the top? And that is really one of the most important factors. You look at the corporation's history of similar misconduct, including prior criminal, civil, and regulatory enforcement actions against it. The timely and voluntary disclosure of wrongdoing and its willingness to cooperate in the investigation of its agents. We talked about that earlier, coming forward immediately. When I coordinate a search warrant with agents at a business, usually within 2 hours, I get a call from the company's counsel saying, I want you to know we're going to cooperate, we will do whatever to help you, and that's the right way to start the dialogue, because they know that's something that the government's going to consider in whether or not to charge the corporation. You may not know this, but if you represent a corporation, your duty is to that corporate entity on behalf of the shareholders, owners of that corporation. The managers and executives typically retain separate counsel because the corporation's lawyer is not representing those individuals. They don't usually tell you that on the first day. They tell you, we represent the corporation and every employee because they don't want you to interview the employees, but typically they retain separate counsel for that reason. The next factor is the existence and effectiveness of the corporation's pre-existing compliance program. And this is really what you're talking about here today. What can you do to set your clients up with a program so that when the proverbial SHIT hits the fan, you can say to the government, we had this policy in place, we told our managers not to do this, we trained our managers on the proper way of handling things, and this is a rogue manager that should not bind this corporation. I wanted to mention that we sort of touched on this earlier, but under theories of respondeat superior, a corporation is responsible for the acts of its managers and employees if the manager or employee is acting within the scope of their authority and at least in part to benefit the corporation. And that principle of law holds true even if the employee is acting directly contrary to corporate policy. So if you have an employee who's doing something to benefit the company, let's take an example that you folks deal with. They're hiring workers, undocumented workers, to help staff the plants and get things done, even though there's an employee manual that clearly lays out that they're not supposed to do that. That employee, a manager, is acting within the scope of his or her authority to benefit the company. The way that these pre-existing compliance programs help you is that in evaluating whether or not the person is acting to benefit the corporation, if they're acting contrary to that policy and procedure, you take that into consideration. Was that really in the company's benefit if the company was telling the manager all along not to do it? You look at the remedial actions, and this is what I was talking about earlier, that any efforts to implement an effective compliance program, to improve the existing one, to discipline or terminate the wrongdoers, to cooperate with the government, to pay restitution, all of those things, the earlier they come in, the better it's going to help the corporation. A very important factor, and I think this is really where defense counsel comes in, is the collateral consequences of indicting a corporation. That's another factor that really, I think, sort of can weigh heavily in favor of not indicting a corporation. And what they mean by that is there a disproportionate harm to shareholders or pension holders, employees, or other people who are related to that corporation who had no participation or even knowledge of what the corporation was doing in terms of wrongdoing? If you're going to bankrupt a corporation by indicting it, you weigh that factor heavily. And so one of the best things I see defense attorneys do is come to me and tell me the story of that corporation, tell me what they mean to that community, the employment, the history of the corporation, those sorts of things to educate the prosecutor so that they have an understanding of what that company means and what the consequences of an indictment would do to the shareholders, the pension holders, things like that. Real quickly, the last two considerations are the adequacy of the prosecution of the individuals responsible for the malfeasance. Do you evince the federal government's interest by prosecuting the culpable managers, or do you also need to indict that corporation? And most importantly for you folks, the adequacy of remedies such as civil or regulatory enforcement actions. In this context, I will often have lawyers say to me, look, we paid a huge civil fine to ICE, or, you know, we've been debarred, we've had all of these things happen to us, we don't need an indictment on top of that. So this is really a prosecutor's Bible, and we are bound to consider these factors. And what I often say in these cases, when lawyers will call and they'll come in and they talk to me, I say, take a look at the principles of federal prosecution and tell me why the corporation should not be indicted with those considerations in mind. Because I ultimately, as a prosecutor, have to answer to these rules.
Well, Tina, you mentioned the Bible, but do the Ten Commandments come down from Mount Sinai at the same time? You mentioned the almost daily email policy guidance from DOJ, but at the end of the day, when you're sitting down with defense counsel on one of these cases, just generally speaking, to what extent do local U.S. attorneys' offices have discretion to make a deal without consulting with Washington?
They have tremendous discretion within the confines of these considerations. It's sort of, I get a sense from your experiences in the variety of the administrative offices that you're dealing with across the country. 94 U.S. attorneys' offices, 94 communities with different interests, and that U.S. attorney ultimately has to represent and respond to that constituency. It's not a political job, you know, the U.S. attorney is appointed by the president, but there may be considerations in that community that cause the priority, you know, my priority is going to be gun violence or gangs, and this worksite enforcement stuff is just not going to be that important. Or it may be really important to a particular community if there's an unfair competitive advantage with respect to this employer and the other folks in the community. I mean, if you have, you know, I've just seen, or the cases that have gone through the pipeline, where you have a really a poor community, a high unemployment rate, and an employer in that community is employing hundreds of undocumented aliens, the prosecutor has to, the U.S. attorney has to answer to that community. And so when you look at these factors and you say, well, how adequate is the civil penalty they're going to get from ICE given what they did in this community, that local factor is going to play.
Is it fair to say the collateral damage provisions you referred to a few minutes ago were a reaction to the Enron, Arthur Anderson situation?
Absolutely. I think the principles of federal prosecution, I don't know when they first came out, but they are revised with time. And the Department of Justice learns. They learn from prosecutions and their past mistakes. In the context of worksite enforcement, I wouldn't call it a past mistake, but I think you will not see mass pleas by 400 undocumented workers at one time in a tent in the middle of the country. I think it just sort of, I'm not passing judgment on whether it was appropriate or not, but the department certainly got feedback that it doesn't want to see again, and so it sort of steers you away from that sort of resolution.
Okay. On the time we have left, would like to shift, Tina and Eric, to the NPAs and DPAs specifically in the immigration context. And the conference materials, which are available somewhere online, Marcine, I think maybe everyone got an email, or they will, or whatever, but something, if you haven't read, you really ought to take a look at is the IFCO settlement agreement negotiated by Tina and Counsel for IFCO. And I want to talk about that only briefly, not because it was a good deal or a bad deal, but because, and Tina probably thinks it's a great deal, but it's out there. And it's like a resource. So going forward, any other U.S. attorney that is thinking about entering into an agreement of this type with a corporation facing criminal prosecution is without question going to refer to the IFCO agreement to see what was in there, and you know, they might want to use a lot of it. And just like to summarize very briefly bullets of the major elements that appeared in this agreement. A very detailed statement of facts, almost reading like allegations of wrongdoing, an acceptance of responsibility for the wrongdoing on the part of the corporate entity, a highly defined standards of ongoing cooperation between the corporation and the U.S. Attorney's Office, monetary penalties, and Tina, when I finish my list, I'd like you to comment on the monetary penalties and the forfeiture provisions, because I don't think they're well understood by us in the immigration world. A implementation of a compliance program or revisions to a pre-existing compliance program, and that would include an internal compliance officer, employee of the corporation who would oversee the compliance activities subject to the approval of the U.S. Attorney's Office. In this case, appointment of an outside corporate compliance counsel, also known as a monitor to some in the white-collar criminal defense bar, who would oversee the overall compliance program, supervise training, also report to the U.S. Attorney. A hotline, telephone hotline, kind of a Sarbanes-Oxley type thing, so employees could anonymously report any wrongdoing. The ever-popular enrollment in E-Verify for new hires. For existing hires, utilization of SSNVS to see if there are any Social Security number no-match situations. The training program I previously alluded to. Annual I-9 audits by an external firm with the results submitted to the U.S. Attorney under penalty of perjury. Development of a protocol for no-match letter receipt, what you do, when you do it, that sort of thing, not a bad idea. Oversight of contractor, subcontractor compliance, not quite what we've seen from the Walmart case, but it's out there. We're requiring contractors and subcontractors to certify whether or not they use E-Verify, whether or not they've received any no-match letters. Very significant self-reporting obligations by the corporation if further violations are discovered, that they're required to share that with the U.S. Attorney. And finally, the U.S. Attorney has the sole discretion to determine whether a breach of the agreement has occurred. So that's pretty comprehensive, Tina. I think you've really kind of covered, you know, all of the issues. So I'd just like to raise some areas of concern and question and kind of get your reaction, and Eric, your reaction to it. First of all, not in the context of the IFCO agreement or immigration NPAs, DPAs specifically, but just broadly, many in the criminal defense community have been critical of this because there's really no judicial review and an opportunity for the courts to rule on, you know, whether the acts truly constituted criminal violations. And I know the pros and cons with that, and Tina, how do you react to that criticism?
Well, let me just explain the sort of agreement that we reached in IFCO was sort of a hybrid. And when you talk about NPAs and DPAs, what he's talking about is on the continuum between just civil or administrative remedies and a criminal indictment. And a middle ground is either a deferred prosecution agreement or a non-prosecution agreement. And there's actually a third thing that you can use called a consent decree, which is a civil remedy. A deferred prosecution agreement involves the U.S. attorney actually filing a charge against the corporation in court. They file their agreement in court, and there's a certain amount of time by which, or under which, the company has to comply with that agreement. There is court oversight on that. On the non-prosecution agreement, you agree not to prosecute the company if they comply with the agreement for a certain period of time. And what you typically do is waive what we call the statute of limitations. In case there's a breach during that 4 years, you can bring the charges that you put off 4 years earlier. That is not filed with the court. And the third option, the consent decree, you file that with the court. That is what happened in Walmart, where the government obtained an injunction against Walmart for that period of time that enjoined them from hiring illegal aliens. There's court oversight, there's regular reporting, there are all the strictures of having a consent decree in the court. So what we did was sort of a settlement. It's a non-prosecution agreement sort of combined with a consent decree. So in answer to the court oversight, in 2 out of the 3 circumstances you have oversight. And I guess I would say it sort of depends on your experience with that U.S. Attorney's Office and how much you trust them and trust the office to be fair in evaluating the violations. And if you had a very contentious relationship or didn't trust that there was fair evaluation of the company's conduct, you might insist that it go into court, though the downside is that you would have a charge filed against you in federal district court.
And in any of those situations, it's, I believe, and correct me if I'm mistaken, at first instance, it is the Office of the U.S. Attorney that determines whether there has been a breach
Yes.
Of this agreement. So if you're in a non-prosecution agreement situation, the U.S. Attorney's Office could say, from that long list of requirements that is in the IFCO agreement or in some other agreement, if that some action by the employer constitutes a breach, and the U.S. Attorney's Office makes that unilaterally, makes that decision unilaterally. And in the deferred prosecution context, that's really still the case. But at some point, perhaps a judge might say at the end of a prosecution, and by the way, U.S. Attorney, we think you overreached.
Well, I think the problem with you can't have a judge oversee the non-prosecution agreement because the court has no jurisdiction. And so it's really a decision by the corporation. Do you want that extra level of review? Let's put it before a judge in district court. Do you want to spare your client or make the decision that it's worth the client not to have a pending federal criminal charge against them? Then it's no different, I guess, than most plea agreements where the government makes the sole determination whether there's been a breach of that plea agreement by the defendant.
This may be a dumb question since I'm not an expert in your field, but why is it that you do not typically see employees, like key employees, included in the NPAs and DPAs?
The NPAs and DPAs are solely to settle the liability of a corporation under these considerations. And that's an important point. You cannot use an NPA or DPA to settle away the liability of your employees. So you can't say, for example, even with a corporate charge, just charge the corporation and let the culpable folks go. Those are separate considerations, and the entity of the corporation is treated differently, or with, they're independently evaluated. Although one of the considerations is, has it been sufficient to indict the 5 responsible managers? But that's why they're not included in the deferred prosecution.
Okay, so they would either be indicted, let go, or enter a plea agreement, as the case may be dealt with on a case-by-case basis?
Yes.
Okay. Impact on attorney-client privilege with the oversight, the outside compliance counsel, the reporting obligations, certainly some considerations there. Eric, Tina, how do you feel about that?
In these worksite enforcement cases, it's no different than in any other corporate context. And that's why I talked earlier about your responsibility as a lawyer is to that entity and to the shareholders or owners of that corporation. There are always tensions among the privileges that the corporation holds, the privileges that the employees hold. But I think what happens in these non-prosecution agreements and settlements with the corporation is they do agree to completely cooperate with you, and that includes identifying any wrongdoers that they know about, providing you with any documents, giving you whatever you need for the grand jury, helping you with the trial. They're obligated to do anything you would want from a defendant who's cooperating with you. I think those tensions are there, but I think that exists wherever you have a separate entity with separate obligations.
Well, it can get a little confusing in terms of who's representing who and in terms of the attorney. And the morning panels plus the panel right before touched on that. You know, the distinction between representing the management and the corporate entity. And, you know, when you layer on top of it an agreement of this type, I suppose by that point everybody's real clear who's doing what and what their roles are. And certainly for the remaining management team that hasn't been indicted, you know, presumably they have bought into the program and, you know, will cooperate as required in the agreement. But, you know, it seems to me that an agreement of this type could be a real culture changer, you know, within a company, because between the compliance program and the self-reporting obligations imposed on the corporate entity, you know, concerned that could pit on a go-forward basis, the employer against the employees and kind of create this feeling of, you know, Big Brother, you know, is watching us every moment. They're lurking behind us, and, you know, what that might do to, you know, the corporate morale and productivity going forward.
And I think this also really touches on something that Sharon mentioned in her panel, which is, as immigration attorneys, it's really important to know your limits and to know at what point you may be exceeding your area of expertise or perhaps even your comfort zone, and reach out and involve experienced criminal defense counsel when you're contemplating entering into these agreements, or not just entering into these agreements, but when the prospect of criminal charges first emerges. That's the point at which you want to reach out and make sure that you're getting the appropriate guidance from corporate counsel, whether you're in a big firm like you know where I am, where I can reach out to somebody within the firm, or whether you're a sole practitioner where there are any number of capable and competent white-collar defense counsel whom you could reach out to assist with this.
See, I usually use the grand jury subpoena as an indication that maybe I, you know, need some help.
Or the Washington Post in my case.
Yeah.
Yeah, right. Yeah, in your case.
Or a search.
But I had a question with respect to the NPAs and the DPAs, because it seems to me that once a company's indicted, that's going to be public. So if you're in a DPA negotiation, then the cat's out of the bag. But is there any way to keep an NPA under wraps so that it is notwithstanding whatever public disclosure obligations a company might have under SOX? Is there some way to keep the non-prosecution agreements confidential?
There are. We have a particular provision in ours in which the company agrees that the settlement agreement would be public, but that provision could be negotiated like any other. I mean, you know, I was talking with Sharon about this yesterday. Because you can't put a corporation in jail, one of the primary considerations in prosecuting a corporation or settling with a corporation is deterrence. You typically look to change not only the culture within that corporation itself to immediately obtain remedial steps by that particular corporation, but also to affect the conduct across that industry. You know, whether it's an environmental crime or, in our case, hiring of undocumented workers in particular industries. And so the publicity involving a particular settlement is something that's important to the department and to the agency, because they want deterrence through their work. And Sharon said, well, often, and I think she said here today, my clients don't want the publicity. And I suggested to her that that's actually a lot better than a criminal indictment. So if you could sort of say, you know, we'll work with you, we'll tell every subcontractor we work with for the next 4 years that we think that hiring undocumented workers is abhorrent, and we abide by the immigration laws, and we expect them to do that, the more you spread the word, the more you're helping the department and ICE achieve its objective of deterring that kind of conduct.
Well,
I'm sorry, if I could, and let me suggest that that's also something that you could involve in your negotiations with ICE counsel outside of the criminal context. Again, it's not necessarily going to impact where you are in the matrix, but it could very well impact the tenor of the negotiations and where you end up in terms of your bottom line fine figure. And I have negotiated successfully for my clients that ICE would not put out an independent press release with respect to the fine or the sanction that was imposed. And it's a kind of illusory victory, because ICE is still going to be required in some instances to disclose to any kind of oversight authority or some other requirement, or respond to some other legal requirement that they disclose companies that have been fined. But at least this avoids the press release that was in the spreadsheet that Wendy showed us earlier, in which company after company after company was listed as a bad actor.
In terms of the deterrence factor, Tina, there have been, by now, a number of high-profile prosecutions besides IFCO. There's been the Pilgrim's Pride. Tyson's had their issues, though had a better result for them. Do you really think this has changed industry behavior?
I suppose I've been watching the behavior since 2005, when we started the IFCO investigation, and I have seen a tremendous change. I mean, the fact that this panel is taking place, that this book has been published, that Dan talks about the context within corporations, the fact that people care about, they're advising their clients, it really has changed, and I think the U.S. Attorney's offices and ICE, they see that change and they want it to continue. So I don't think it's going away anytime soon.
Well, I think we'd all agree on that. We're about out of time. I would like to invite anyone with any questions before we conclude to raise them. Going once, going twice. Okay, well, would like to thank you very much for your attention and being here. Thank you.